Nick, why don't we go ahead and get started? So if you and the session coordinators can kick us off, please. Thank you.
Great. Well, good morning. Welcome, everyone. Good afternoon, good evening to those online. My name is Nick Smith. I am a member of the Global Public Policy team at VeriSign. This morning, I will serve as one of your site facilitators to assist with the EuroDIG support team, as the majority of our panel is participating remotely. We are excited to have one of our distinguished panelists on my right, here in Tampere, Georgia Osborne of the DNS Research Federation, which you will hear from shortly. Today, you're attending a session organized by the Dynamic Coalition on DNS Issues with support of the DNS Research Federation and VeriSign. Our title today is Mind the Governance Gap, Broadening the Multi-Stakeholder Response to DNS-related Cybersecurity Threats. So, without further delay, let's jump right in, and I'll hand it over to my colleague and moderator for today's session, Keith Tracy. Keith, over to you.
Thank you very much, Nick. Appreciate it. Hi, everybody. My name is Keith Drazik. I'm Vice President for Policy and Government Relations at VeriSign, the registry operator for .com and .net domain names, and operator of two of the Internet's root servers. I'm very pleased to be here with you today virtually. I wish I were there in Tampere with those in the room, but very happy to be here helping to moderate this session. I think this session is going to focus on key questions related to the roles, responsibilities, and capabilities of various operators in the DNS ecosystem, and questions about perhaps existing governance gaps in responding to DNS-related cybersecurity threat. I think the key issue here is, as operators in the DNS ecosystem, each company, each operator has its unique role, responsibility, and capability in responding to and mitigating online harms and DNS security threats. But I think there's a real opportunity and a need, frankly, for improved collaboration, coordination, and communication among the various operators in the ecosystem. And particularly important is the role of regulators, and the rules under which each of these participants in the DNS ecosystem operate. So I'm going to just briefly introduce our panelists, and I'll ask them individually to introduce themselves. But I'm going to speak in a moment to what's going on in the GTLD registry space, or GTLD registry and registrar space. And then I'm going to turn it over to Polina Malaya from Center to talk a little bit about what's taking place in the CC space, the country code top-level domain space, to talk a bit about NIS2 and issues related to compliance, best practices, and extraterritoriality effects. I'll then turn to Thomas Rickert from ECO, who will discuss more about NIS2 and also the recent Quad 9 Sony case, and governance gaps in relation to content-related issues and risk for fragmentation. Then I'll turn to Mark Hughes from DXC, who will speak to perspectives of the hosting and proxy providers, including governance gaps surrounding content-related issues. And then we will turn to Bruna Santos, who's a digital rights activist, and we'll speak about implications for freedom of expression when it comes to using the domain name system, or the DNS, as a takedown mechanism for content-related matters. And then finally, we'll turn to Georgia Osborne of the DNS Research Federation, who will talk about gaps in governance related to blockchain and naming spaces related to and relying upon blockchain. So with that, let me give a brief update on some recent developments in the GTLD space, the generic top-level domain space. Approximately 6 months ago, actually at the very end, December of 2022, the GTLD registries and registrars initiated contract negotiations with ICANN, the Internet Corporation for Assigned Names and Numbers, where we have contracts. We have contracts to operate the registry and registrar functions in the GTLD space with ICANN, and those contracts are essentially the governance mechanism that requires we as registries and registrars to perform certain functions, to act now to mitigate on DNS abuse related matters. And so there is a public comment period. So after the last 6 months of negotiations, and these were voluntary negotiations with ICANN initiated by the contracted parties, we concluded on some new obligations for registries and registrars to act to mitigate DNS abuse within our area of responsibility, capability, and response, and in our remit. And those areas would include the DNS security threats of phishing, farming, malware, botnet command and control, and spam when spam is used as a delivery mechanism for those other 4 types of abuse. And so registries and registrars in the GTLD space have stepped up, have agreed to take on new obligations, new enforceable contract obligations, to do more and to do better and to raise the bar when it comes to actually mitigating DNS abuse. And so we're very proud of those developments. The contract amendments and a compliance advisory are currently out for public comment. And we expect that within the next several months, we will be moving to a vote of the registries and registrars to take on those new obligations. There's still the public comment period to be concluded, but we feel very strongly that this important step will make a difference in improving mitigation of DNS abuse within our area of responsibility in the GTLD space. We also expect there will be more policy development work to take place within the ICANN multi-stakeholder community. There will likely be a policy development process initiated at some point in sometime later this year or early 2024. And we look forward to working with others in the community to identify other areas that require policy development. So that's a quick update on what's taking place in the GTLD space. And with that, I would like to turn it over to Paulina for an update on the CC space and your perspectives, Paulina, on NIS2 and anything else that you'd like to talk about today. So thank you.
Thank you, Keith, very much. And good morning, everybody, from my side as well. Also very sad to not be there in person in Tampere, but yeah, very happy to be at the panel today. And thank you for EuroDIG for accommodating remote participation. So as Keith already briefly introduced, I'm Paulina and I'm a policy director at Centre. And as you know, Centre is the association of European national country codes top-level domain registries. And today I was asked to give also a bit of a regulatory overview and to briefly zoom in on some of the interesting developments in the CC space. So from the legislative perspective in Europe, there are 2 legislative instruments for the purposes of scoping the discussion on DNS abuse. So first, of course, you've all heard about the EU NIS2 directive. So NIS2 makes a unique connection between the accuracy of domain name registration data and tackling the so-called DNS abuse without giving a definition of what it is. And second, there is also an e-evidence regulation that has been recently finalized in the legislative negotiations. And it stresses the importance of access to so-called subscriber data held by technical community actors, such as domain name registries, registrars, but also regional IP registries. And that's primarily in the context of access for law enforcement authorities. And the main purpose for that type of access to the technical data, and that also includes domain name registration data, is to identify actors behind malicious websites. So to summarize, both NIS2 and the evidence regulation stress the importance of access to particular data held by technical community actors, primarily for the purposes of identifying malicious actors. And that I think this is quite important when we're scoping the whole discussion on DNS abuse. So to this end, the NIS2 establishes an elaborate accuracy obligation that is applicable to all registries and registrars operating in Europe. So there is that extraterritorial effect of European legislation. And according to this accuracy obligation, certain registration data shall not only be kept accurate, but also verified. And similarly to e-evidence regulation, it should also be provided upon lawful request to all legitimate access seekers that primarily include law enforcement authorities. So for the EU legislator, it doesn't really matter whether we are talking about DNS abuse, cybercrime, or technical versus content abuse, as access to registration data or subscriber data is in general seen as one of the key elements in conducting further investigations by competent public authorities. And providing access to domain name registration data based on a clear legal basis is also a longstanding practice amongst European CCTODs, as there needs to be a clear legal base in order to be able to obtain such data, since registration data usually contains personal information. And that's also quite important to keep in mind that EU CCTODs in general are really long-standing examples of zones with redacted WHOIS information. So most of the WHOIS information is not publicly available, but at the same time, they are continuously being referred to as the least abused TODs, according to numerous studies. And yeah, we just have to move on from this notion that WHOIS containing personal data cannot be made public, and NIS2 also actually recognizes that, despite some of those discussions sort of kind of having a spillover effect from the ICANN community. So coming back to accuracy again, it's seen, so the reliability and accuracy of registration data is beneficial from two aspects. And here I maybe zoom in a little bit already on what EU CCTODs are doing. So simple validation checks might help keep some rogue actors away, especially those that are rather opportunistic or script kiddies that just might exploit the weak registration processes. But I think for more complex and elaborate criminal campaigns, cooperation with competent public authorities is the key, and specifically also to cases where there is a content-related abuse. So, for example, one of the examples is a fake web shop, and so here competent public authorities usually come with a notification or a trigger or a report that then triggers more identity checks, or might trigger more identity checks from the domain name registry side. So, and here, I guess I would have to also maybe again go back a little bit on the scoping exercise. So taking action based on inaccurate registration data, as opposed to qualifying the abuse, the form of abuse between technical or non-technical, actually allows CCTOD registries to take action based on something that is within their remit and within their reach. So providing inaccurate information is seen as a breach of contract, and therefore an appropriate action can be taken in line with the internal procedures of a registry. So, and here it's very important that that internal procedure may also involve allowing the domain name holder to rectify that data and not lose a domain name. So malicious actors are usually not interested in passing those additional identity checks, but it's important to allow domain name holder to react if their domain names have been compromised without their knowledge. So here it's also very important to keep in mind that identity check or accuracy check, but a simple validation check cannot be automatic, since there might be quite a drastic consequence on a domain name holder as a result of that automatic action. And there's a lot to learn from European CCTOD experience that have consistently shown that they're best in class. As our latest data accuracy paper shows, there's a variety of accuracy practices out there, but the crux of strength of EU CCTOD space is diversity in approaches. So it allows to be flexible, adapt to national context and business model, and there's no one-size-fits-all approach to accuracy. And this is quite important to, I think, keep in mind when we talk about NIS2 compliance. And perhaps, it's also important to note that when it comes to European CCTOD space, We learned from our survey that was conducted in the context of data accuracy paper. Most of the European CCTODs perform registrant identification checks or verification checks based on ad hoc trigger. That includes a range of different types of so-called triggers for that. For additional identity checks. There might be a complaint from third-party anomalies or failing a simple syntax check, and only a handful of EU CCTODs have relevant electronic identification methods in place for verifying registrants' identities. And this is one of the NIS2 implementation challenges and actually a governance gap that I would like to highlight as one of the perhaps potential topics for discussion. So there is a general lack of functioning and available electronic identification schemes, especially for cross-border usage. And there is also definitely a lack of a proper analysis and impact assessment on human rights as a result of verification and stringent verification procedures that might be imposed as part of NIS2 implementation. So the moment identity verification becomes more widespread and stringent, there is a risk to unnecessarily hamper access to essential digital infrastructure. So in general, these type of concerns, what it means for an overall accessibility of essential infrastructure, really lack from the discussions, and including on the legislative level. And I guess I've already spoken so much, but my last point, and then I hand over back to Keith, is from our end, is also important to keep in mind that a connection between accuracy and the levels of abuse are actually not that clear-cut, despite some of its emphasis in the legislative discussions, since from the publicly available research, there is only anecdotal evidence that cybercriminals choose to avoid TLDs that strictly verify registrants' identity, and it is yet to see the benefits of NIS2. And of course, need to always keep in mind that cybercriminals are very quick to adapt their means, and we might expect new ways of circumventing verification checks. And here, I will conclude that cooperation with competent public authorities within the rule of law is the paramount importance for tackling DNS abuse. And thank you with that. So Keith, back to you.
Yeah, thank you very much, Polina. That was great. A lot there. And clearly there are a range of challenges. I'll just follow up by noting that, in the CCTLD space, clearly, each CCTLD is subject to the laws of its jurisdiction and the regulations of its jurisdiction, in addition to the broader European Union laws, and that there's quite some, variation or potential variation or variability in implementation across the actors. So it's quite a complex web of requirements, obligations, and implementation when it comes to this range of issues. Just to sort of reinforce, registrant validation or verification is a challenging process with, I think, uncertain value when it comes to the mitigation or identification of DNS abuse. I think there's a general recognition that DNS abuse is DNS abuse regardless of who's doing it. And if you identify phishing, farming, malware, spam, botnet command and control, that it is what it is, right? And whether and it's unclear whether knowing the registrant or knowing the identity of the registrant matters at that point. I also recognize that there are types of online harms out there where it may be helpful to be able to identify who the actor is, but perhaps not at the at the registry DNS level. So I think, but that's an ongoing conversation. And then you raised a good point about the implications for registrants themselves and the need for registrants to be able to have transparency and recourse and the ability to, manage their systems. And of course, validating a registrant in one particular jurisdiction where there's commonality around an identification number or sort of standard framework is certainly easier. And I'll speak to the GTLD space, much easier than in the GTLD space where we have global operations in hundreds of countries that have varying requirements or varying ID facilities, identification capabilities. So it is a challenging situation. I think you covered some great points there. So thanks, Paulina. Thomas, if I could turn it over to you next. So Thomas Rickert from ECO, the floor is yours.
Thanks so much, Keith, and good morning, good afternoon, good evening, everybody. I hope that I will be able to manage, being cohesive in my talk, because I just came back from ICANN 77 and still suffer from the jet lag quite a bit. So I'm Thomas Rickert. I'm Director Names and Numbers with the ECO Association, which is an Internet Infrastructure Operator Association with more than 1,000 members from more than 60 countries. And I'm taking care of the part that deals with the domain name industry and trying to take care of the interests of registries, registrars, and other players in the field. My day job is being a lawyer. I have a law firm based in Bonn. And for full transparency, I will be talking about the Quad 9 case a little bit, and my firm represents Quad 9 in that matter. Now, there is a worrisome trend that we can observe over the last couple of years, and that is that we seem to be moving further and further away from the actual perpetrator, trying to catch the bad guys, and closer to the root. So we don't seem to care that much about finding the actual person that is committing a crime, but rather go to the infrastructure provider, and in that regard, going closer and closer to the root, i.e. to resellers, registrars, and ultimately registries, to just pull the plug on a domain name and thereby end allegedly certain scenarios of abuse. And I will try to shed some light on why I come to that conclusion in the next couple of minutes. But I think it's important to recognize that when we talk about abuse, we need to make a distinction between technical abuse and content-related abuse. And these lines are getting very blurred these days, particularly to name just one example. The European Commission has commissioned a study on DNS abuse, which has been published early last year. And there, the term DNS abuse, which was originally meant to be related to technical abuse, has been broadened quite a bit to cover all sorts of contents, as long as they're accessible via the DNS, and that's virtually everything. And in my view, we need to be very clear on what we're actually tackling. We need to talk about the motivation behind trying to get things done or getting infrastructure providers to action, and that is to make the distinction between altruistic motivation, which would be true for malware, phishing, farming, botnets, where regardless of the content that is concerned, and ultimately malware might also be regarded as content, if you wish, this is bad for everyone who gets that on their machines, versus egoistic motivation, and that would be interests of rights holders, trademark owners, copyright owners that want to get their own position enforced. And one of the distinctions between the two is that in order to determine whether something is technically bad, you can take a look at what's used for the criminal activity for the campaign, without being required to ask anyone to make a determination. Whilst for in order to make a determination on whether someone is a rights holder or whether he's a licensee of a trademark or certain content, you would always need a third-party information to make that decision. So I'm just wanted to put that at the very beginning of my intervention, so that, because sometimes even during my short intervention, we need to be very clear on what we're actually discussing. Now, the Quad 9 case has stirred up quite some dust and gained a lot of interest. And what happened in that case? Quad 9 is a foundation based in Switzerland, and it acts as an independent recursive DNS resolver. And the rights holder has obtained a preliminary injunction that has been confirmed in a court decision in Hamburg in the meantime, that they should stop resolving certain domain names that point to allegedly websites that contain links to copyrighted material. And so that was the preliminary proceeding. In the meantime, there has been the first instance decision in the main proceeding that even went further, and not only holding Quad 9 accountable as a disturber. Störerhaftung is the German term that I think is used quite widely in other languages as well, because that's a speciality of the German legal system. But actually, the court in Leipzig has found that Quad 9 is liable as a wrongdoer, which would also expose them to the risk of damages by the rights holder. And that decision in Leipzig is more or less a copy of a decision that's been made against Cloudflare in Cologne. Both of these cases are in the appeal stage at the moment. But what the courts did is they applied the principles that have been used by the European Court of Justice for hosting and platform providers to DNS resolvers. And I think that's quite a disturbing new facet of this, because it means that, you know, if you don't take immediate action and stop domain names from resolving, you are exposed to liability. And this is worrying because unlike hosting companies, DNS resolver operators don't have a contractual relationship with those who offer content online. They don't know who they are. They neither have a contract with the user nor with the publisher of content. And it's not that easy for them to just pull the plug and suspend a customer, as YouTube in that case of the European Court of Justice could. You know, so that's something that's worrisome. Also, you know, the Störerhaftung would be bad enough, but for Störerhaftung we have an elaborate scheme of subsidiarity that has been established by the by the German Supreme Court, and that means that you know, we have decisions for access providers, we have decisions for a decision for a registrar, where there are strong principles of subsidiarity, whereby you have to go after the wrongdoer first, you have to go after the hosting company first, and only then, as a matter of last resort, you might be able to go higher up in the ladder. And what's been remarkable in the Quad 9 case is that although the German Federal Court has stated that it is perfectly or it can be required for the rights holder to go after a hosting company in Europe at least first and take legal action against that. In this case, the rights holders have tried to serve a letter to the hosting company, and the hosting company, you know, they were in a high security building where there's security folks, and they asked the security folks, well, here's a letter for the hosting company, and they said, okay, we're going to call them up. They called them, they said, well, we're not going to accept the service, and then they said, okay. And the court said that is sufficient as an effort to go after the hosting company, and we think that that is not good enough, you know. So I think that that maybe that's convenient to go after resolver operators and maybe others first, but I think that more can be done, that subsidiarity needs to be, the system of subsidiarity needs to be followed, because otherwise we get to disproportionate results. Also, you need to make sure that, you know, if you get such a court order, that you make that you stop a domain name from resolving for a given jurisdiction. But this is virtually impossible for an operator that's global, that's working at the global scale, because unlike an access provider that has a customer base and they know pretty much who's dialing into their infrastructure, the recursive resolver operator does not necessarily know where the customers are coming from. So a blocking order, if you wish, issued in one jurisdiction may easily lead to a global block of that given content. And we know that legal systems vary quite a bit around the globe. Last word on that is that the courts in all these court decisions on the Quad 9 cases and the Cloudflare cases did not regard DNS resolver operators as providers of telemedia services according to the e-commerce directive or now the Digital Services Act. And we think that this is worrisome as well, because when the e-commerce directive came to life, I think nobody would have thought that someone would ever challenge a DNS resolver operator in isolation. But most access providers actually function as a DNS resolver operator as well. So the access provider enjoys privileges when it comes to liability. The courts have denied these privileges to resolver operators, which means that I, as a representative of a rights holder, would just send a letter to an access provider, not in their capacity as an access provider, providing access to the network, but in their capacity as a DNS resolver operator. And that would basically erode the entire system. And the Digital Services Act, in one of its recitals, explicitly refreshes our memory that a DNS resolver operator should be part of that scheme, but that didn't help in our argumentation so far. We hope that this is going to be fixed during the appeals phase, but this is where we are at the moment. On NIS2, we already heard a little bit from Paulina that we have this Article 28 in NIS2, which is the odd man out in this directive, which otherwise deals with security questions and all that. And then this Article 28 requires registries and entities offering domain name registration services, that would be registrars, resellers, and also privacy and proxy services, to maintain a database of registration data, validate data, publicize non-personal information immediately, and also process disclosure requests. Now, there is the fear that different member states will implement or transpose these requirements into national laws in different ways, because we already see a diversity of approaches in the CC world, and rightfully so. We want to maintain that diversity. But there is the fear that some lawmakers think that, what they've seen in certain CC TLDs, can just be copied over to the GTLD world. And if we, let's say, had one jurisdiction requiring pre-validation, the other one requiring post-validation, that different data elements should be validated, that would be bad. It would be difficult for the operators, but it would also be a bad user experience. If you put some domain names into your basket shopping at a registrar, and then you find out that you have all these different requirements to fulfill, it might deter you from actually proceeding to purchase certain domain, a variety of domain names. And therefore, we hope that the European lawmakers will keep the legal requirements to a minimum, and that the guidelines that are going to be issued will also be agnostic to specific technological approaches, so that we can maintain the diversity that we already see, but keep things as harmonized as possible in order to, not that much disrupt the user experience in the marketplace. Also, NIS2 seems to be the first regulatory initiative that uses the term DNS abuse without saying what it is. But it looks like, and I might be wrong, but it looks like the European regulators are of the opinion that if only we had enough accurate registration data, we would be able to end all the bad stuff that we see on the internet. And I think that, this is something that we all need to jointly make sure is not a perception that sort of manifests itself in everyone's thinking. Because when it comes to compromised web spies, for example, from which malware is disseminated, you can validate the heck out of the registrants. That won't help a thing. And also for technical abuse in virtually all cases, the registrar or the registry doesn't even need to know who the registrant is in order to take action to mitigate that harm. So let's try to come to balanced approaches in order to make sure that we get measured requirements during the transposition of NIS2. And I think what's important is that we remind everyone that everyone up and down the stack have their respective roles and responsibilities. So we are pretty much focusing on the DNS industry at the moment because it's convenient, right? If only we got ICANN to come up with a policy requiring registrars to pull the plug on domain names that do certain things wrong, then you wouldn't need to go to remote jurisdictions and communicate with registrars. You would send them one email asking them to take things down, and if they don't react, you go to ICANN and ask ICANN to take care of that via ICANN compliance. And we must not allow for ICANN to become the global content police, and ICANN can't do that, even if ICANN wanted to, because ICANN has a very limited technical mandate. And if we allowed that mandate to be eroded, ICANN would lose its credibility in no time. So let's try to help everyone understand what the players do technically, so that we get court decisions, that we get laws, that we get the action required by the various players. One thing's for sure, there's room for improvement, no doubt about that, but we need more interaction between the various players, between hosting companies, registries, and registrars, so that we take action on technical abuse swifter than we currently do. So let's keep policies harmonized for domain names. Let's keep ICANN's mandate narrow, and let's educate about the roles and responsibilities of the various players up and down the stack. Over to you, Keith.
Thank you very much, Thomas. Great remarks and really detailed information about both Quad 9 and the NIS2, Article 28. I would just to reinforce a point that you made, and that is the importance of informed regulation, informed policymaking, to ensure that regulators around the globe understand the key roles, responsibilities, and capabilities as they're developing, policies or regulation that impact this ecosystem. And I think I know that your organization, ECO, and the Top DNS initiative have been involved and engaged directly with the European Commission and others in helping to inform and to bring some improved understanding of these distinctions on a range of issues. So I guess one follow-up is there anything more that we can do, or better coordination that we can have in that regard, specifically engaging with lawmakers to ensure? I'll just note, 10 years ago, 15 years ago, regulators and lawmakers generally didn't understand the DNS at all, if they even knew what it was, right? But clearly in the last 5 years, regulators and lawmakers are becoming, much more aware of this ecosystem and what we do, and the importance of what we do. But they're still not there in terms of fully understanding the distinction between the various actors, the different layers, and all of the implications. So I just think there's more that we need to do to engage as a community, and also in a multi-stakeholder way, to ensure that there's a recognition of the implications for freedom of expression, for registrant rights, for end user rights. Thomas, I don't know if you have anything else you want to add on that point, and then I'll hand it over to Mark here shortly.
Why don't we go to the other speakers, and then we pick it back up when we go to discussion?
Yeah, sounds good. Thanks very much, Thomas. And we will get to a discussion and a Q&A as well here very shortly. So Mark, over to you.
Well, thank you very much indeed, Keith, and thank you. It's always hard to go after such excellent comments that both Thomas, Paulina, and others have already made. But just to really give you a perspective from the other end of this, if you want, which is the actual end where we see the harm actually happening every day. So I'm responsible for security at DXC Technology. We're an IT services provider, so we provide services to large corporates to run their IT for them. And it's very much at that end that I come with my comments today. And what I really wanted to start by saying is that it's day in, day out that we see significant harm being created by the types of bad actors that we have already been referring to. And when I talk about significant harm, it's probably just worth pausing to actually understand what that really means. That means that bad actors are often successful in crippling organizations, whereby they may successfully take down their entire operation for hours, if not days, sometimes even weeks, especially with the rise, as we know, of ransomware. But it's obviously not just ransomware, it's all sorts of other types of actors and techniques that we see across the board. And it's easy to talk about these things in slightly abstract ways, in throwaway lines, but what it really does mean for many organizations, which then has a knock-on impact onto their customer base, is their ability to not actually function at all, and then to get into some significant, related harm, not just in terms of service, but also in terms of financial impact. And of course, that isn't limited to services which we could do without. That's obviously includes essential services. Increasingly, we're seeing health services being targeted on a very routine basis. And there's a few comments that I would come with on that. Really, the first thing that I would observe in most of these types of attacks is that obviously bad domains, phishing, all of the things that we have been referring to today are involved in that type of activity, in those nefarious activities. So this is a really, really important topic. And the reason why I wanted to be on today, and I had the pleasure of being invited here to be today, is to really just reinforce and emphasize how significant the issue is. To put it bluntly, in terms of really defending against the type of activity that we are seeing, we are not in a position in terms of defense to be able to use the mechanisms that are in place at the moment to effectively defend against the type of activity. We have to obviously come up with a whole range of technical controls to deal with the issues that we see, how we block, how we identify, how we then respond, and how we then purge the environments that we work in, that our customers work in, of the known bad type of activity that we are seeing. Any activity that we try to take, which we often do, to try and stop, block, deny, whoever it may be, whether it's a hosting organization, a registrar, a registrant, to stop them from using those domains is almost, I'm going to use this word, immaterial in the grand scheme of how we're defending against types of threat actors. And the reason for that is quite simply that the time taken for activity to be taken doesn't correspond to having to deal with an actual event itself. So firstly, we have an issue of timing, that any takedown type activity that we need to see doesn't happen in any way quickly enough to have an effect on the actual incident itself. And with that, we also see a significant lack of sharing across the different environments. And what that means, again, is that there is a lot of confusion about who's actually responsible for what. I think Thomas has very clearly articulated where there are some clearly issues in terms of governance around who actually is doing what, let alone who's responsible for what. And that then manifests itself in our ability not to be able to really do very much. That lack of sharing between these different entities really has significant implications in not being able to do anything. So just turning a bit towards NIS2, which Polina talked about so well, and that is that I think there is some, you can see it's a laudable attempt to try and begin to get hold of this problem. There's, I think, as we've already heard, some very loose definitions in the NIS2 directive, not just in terms of DNS-related activity, but more broadly as well, which aren't necessarily as helpful as they could be, but it's certainly a step in the right direction. And I think the starting point of trying to get underneath the integrity and authenticity of who's registering and who are behind some of the domains is certainly a good step forward. And I wouldn't dismiss out of hand, from my point of view, the need to actually try and get back to some validation of who the bad actors are behind some of these domains, although noting the fact that it's not necessarily just establishing authenticity doesn't really get you that far, in the sense that there are many different ways of obfuscating at that level as well. But the reason why I say that this is not a bad thing is that what we increasingly see through my lens of the actual net output, if you want, of this bad activity and this abuse is that there are patterns that we can see that develop from different bad actors. So at the very least, having some idea of the type of actor that's behind certain types of activity does help us understand more who, not necessarily who it is, but the groups that are behind this and the tools, techniques and practices, the TTPs that they are using. And that does then help us in our defense to understand where they might pivot to in terms of what their next activity might be. Every cyber incident involves multi-layers of types of abuse, and whether it starts with the type of stuff we're talking about today, but then there are obviously other techniques that layer upon that to be able to get to the result that they want to get to. So being able to actually identify at some point and have some maybe embracing some of what we're talking about here today, better governance around this might allow us to then be able to get into a position to be able to identify the types of groups behind it, and then to pivot our defenses to try and get one step ahead of what is going on. So, and I think obviously the end state of being law enforcement being able to get better access to, and then potentially to do what we would all want to do, is to actually take some of these groups down, certainly is helpful. So I think just Keith, drawing some of my comments to a close, it's essential that I think that we see more sharing and better coordination across the space, because being at the other end of this, which is the area where we actually see the abuse happening and then manifesting itself in genuine harm to organizations, really trying to crack this in terms of better coordination and trying to address the governance around this is a very good ambition, but I don't think we're anywhere near where we need to be yet.
Yeah, thank you very much, Mark. I couldn't agree with you more. And I think I'd like to come back to this question, maybe for a bit of discussion or in the Q&A session about, what specifically, could we do better, and what needs, maybe some concrete next steps as to how we can better collaborate, communicate, and engage as the various layers and the various actors in this sector. And I think your point about, I think you said a significant lack of sharing, I think is absolutely right. And one of the things that I'd really like to, to get to is to have a little bit more, concrete thoughts and recommendations about like what those next steps might be to improve that collaboration. So we can come back to that. But I think your points are extremely well made. And I really, value the input from sort of that hosting, the service provider layer as well. So with that, I think next we will turn to Georgia Osborne, who's going to actually take us into a bit of a new realm, talking about blockchain and alternate namespaces relying on the blockchain, and to talk a little bit about governance gaps there. And then we'll move on to further discussion. So Georgia, over to you.
Thanks, Keith. And I'd just like to say everyone's comments has been really, really insightful. And one of my background is actually, I worked as an intelligence analyst, previously working on risk and threat. So I sort of look at emerging risks and threats. And it came up as a potential for blockchain domain names, or so-called blockchain domain names, or in other words, NFT domain names, or namespaces that uses blockchain. They've got all sorts of names. The industry itself, there's kind of differing views about this. And one thing I would say is that cyber criminals and attackers always explore new ways to perform malicious activities over the internet. So that's always a given. So there's a clear governance gap in this, but I would first of all say that there's a clear knowledge gap. Not many people know about what blockchain domain names are, how they work, what the implications are. So before I go into kind of discussing some of the threats and risks, I'm just kind of overview of what they actually are and what they entail. So this is an alternative route, and alternative routes are not new. They've sort of always been in existence. This one has gained popularity, and it's gained popularity partly because it's decentralized. So it encourages people who don't want to kind of go through a central body to get their domain name. But also it has different uses. It's not the same as a domain name as we know it. So one of the things that it can do is you can attach your blockchain domain name. So let's say my name is Georgia, Georgia.crypto. I can attach that to a cryptocurrency wallet and then send transactions to and from with multiple different cryptocurrencies. The second use that you can use it for is, I guess it's the same as what normal domain names might have been used for from the, when they first were in existence, in that people can buy them and trade them and cyber spot on them and sort of, in a speculative way. And then the last use case is uncensorable websites. You can actually create content using your blockchain domain name and it be uncensorable. So there's different policy implications for those, but then there's two challenges as well that come with them. The first one being that there's a lot of brand infringement that's going on because there's no central space and no way of governing them. They can easily kind of take names from big trademarks or brand names, and governance bodies can do very little about them. So that's a big problem that we're seeing. And then the second problem is that it increases the risk of name collisions. So you can actually have multiple different blockchain domain names in multiple different blockchains. So that creates confusion as well. There's been several cases of this actually happening, and it will only increase in confusion and challenges as the new, as ICANN announces, new utilities to come forward. So there's a lot going on in that space. So that's a kind of overview of what they are. Now, the challenges of this is difficult to say because it is speculative and obviously has not reached mainstream adoption. One thing that we have done in DNS Research Federation is we've conducted a study about this blockchain domain names and how they have emerged. And actually over the last 3 years, so 3 years ago, it was about 1.5 million blockchain domain names, just looking at the two biggest providers, which is Ethereum name service and also Unstoppable name service. And now it is almost 7 million. So you can see that in the last 3 years, they've become incredibly popular, which only increases any emerging risk or threat that might occur. One of the things that these blockchain or the NFT domain names mean is that because you don't have to register with all your details, it's not the same as having a who is, it can be quite anonymized. So you don't actually know who's doing them. So let's say I wanted to register, I don't know, apple.crypto, not that I have, but if I did, and I wanted to anonymize that, it would be difficult to say who has done that and how to kind of enforce dealing with that issue. Now, in terms of abuse, there's a difficulty in terms of you can now integrate between blockchain and domain names themselves. So you can actually have a blockchain domain name that integrates with the DNS. So therefore you can kind of, depending on how you access the different areas, you can change between blockchain and domain names interchangeably, depending on how the person or how the user has organized that to be. So there's different implications in terms of DNS abuse. I was in an event sort of in the last few days where we were discussing, where we were joking that yes, we've sorted all the abuse on the DNS, so now we have to move on to other challenges. But obviously, that's not the case. This is an emerging gap, and I think it's really important that it's met with kind of coordination. At the moment, it's quite unknown. We're sort of entering unknown territory. No one really knows how big of a thing this is going to be, but it is clear that the knowledge isn't quite there. And I was listening to Keith earlier talking about informed regulation and informed policy making. This is one of the areas that I think does need some more information on how this is working, especially in terms of DNS abuse for kind of the domain name industry, but as well as just emerging issues on the internet that I think us as users have an interest in making sure that it is safe for us to use. So we will have to see whether it does enter any kind of mainstream adoption or anything like that. but I would say that the providers and the regulators should cooperate, not necessarily coordinate. And as we see more decisions from bodies like WIPO, where they've made a decision recently, a joint decision with the blockchain domain name provider Handshake, which basically includes them in all their kind of UDRP and basically deal with brand protection issues. As we might be seeing more of those kind of issues and more kind of areas of cooperation and coordination between the regulators and blockchain domain names, in which case I think that's a very important emerging issue. This governance gap is something that is difficult to fill. I don't think it will be filled exactly, but there are different initiatives going on. So we have something called the Web3 Domain Alliance, which works to try and build some policy around this emerging issue. And we have yet to see sort of different initiatives come up. As the more blockchain providers sort of start to come up, we might see fracturing of different groups, which is also an emerging issue. And this governance gap is probably going to need some real information and kind of knowledge filling to be able to provide some good policies around that. But again, it's kind of a new issue. This is not something that that many of us know very much about. So if any of you have any questions, I'm happy to answer. It's also, I'd just like to say, I'm not sure if Bruno's here, but one of the reasons why people choose blockchain domain names is that it is hard to regulate. So sometimes we've seen that blockchain domain names have been used precisely because they do not want to be shut down or kind of, perhaps they have some material that they want to share that they don't want things to be taken down on, which gives kind of an issue for some of the things that Mark Hughes was saying in his statement. So that's also an issue there. But Keith, back to you.
Thank you very much, Georgia. And this is a fascinating topic for me. And I'll admit it is, as you said, it is new. And I feel like as I start to talk about it, I'm going to be very quickly getting outside of my comfort zone. But I'll note that my perspective on this is that there's a whole range of challenges and tensions and conflicts related to blockchain, and whether that's blockchain TLDs, blockchain domain names, services that rely on blockchain that might at some point need integration, are all different things. Excuse me, and and that there's clearly some challenges with this. And then, of course, you mentioned the tension of interests. The decentralized nature and the ability to be anonymous are all features, not bugs, to many folks who are promoting and who rely on blockchain for some of these services. So, how do you encourage integration, responsible, standardized integration? How do you encourage a set of standards that apply? And how do you deal with these natural tensions when it comes to very diverse interests in such a new area? So I think, thank you very much for your presentation. It's fascinating, and this is an area that is clearly has a lot more to develop. So with that, I don't think we have Bruna with us. I'm hoping that she'll join in the next half hour that we have, assuming we go that long, to be able to bring some perspectives from civil society and concerns about user rights and freedom of expression, a range of other issues as it relates to DNS abuse and domain name takedowns or using domain names to affect the removal of content or online harms. So, but with that, let me just pause and see if there is anybody in the room or online who would like to pose a question, who would like to engage in this conversation. We really would like this at this stage to be a dialogue, and happy to take any hands. Nick, if there's anybody in the room that wants to speak, if I could rely on you to help coordinate there, and I'm happy to help coordinate the chat or the participants list if folks want to put up a hand.
We have one from Andrew. Is there a microphone?
Yes, the microphone is on.
It's on, so you can hear you.
Oh, okay. No, fantastic. That's simpler. So it will be. Hopefully, the remote people can hear. Really interesting presentations and quite diverse set of issues. A couple of general comments and then one specific one. I do wonder on the sort of blockchain domain names, if it's said properly, whether, since the way you describe it is perfect for anyone that is trying to maintain a presence for malicious content. It has all the attributes that you would want if you have those sort of interests. So, you know, is it something that the community, dare I say it, should actively attack that type of domain name, which would probably not go down well with everyone, but you know, I can't think of a good use for it. Or if not actively attack, at least encourage proactive blocking of such domain names through various means. So that's just a thought. I think Mark's contribution highlighted again to me the absolute necessity of having people with OPSEC experience involved in setting of internet standards. And at the moment, virtually none are. And certainly the area where I'm active in the ITF, it's painful because decisions are made which have horrendous OPSEC implications by people that have no knowledge of OPSEC. So they're making technical decisions without understanding the technical impact of their technical decisions. So we need to get more community involved. But then finally, just specifically on Thomas's comments, because I think the Quad 9 case raises some very interesting implications. If I'm honest, I don't see the problem with resolver operators being required to block access to certain domains. The issue, as I see it, is the lack of due process in Germany, because I think the only valid way you should be allowed to do that is firstly by having a court order, so that there's an open process before a requirement is placed on DNS resolver operator to get content, because then that can be opposed as required. But also, if I dare I say, I mentioned in the UK where such a route exists, the content owner that gets the blocking order is required to pay any reasonable costs resolver operators in implementing the block. Because at the moment, the resolver operator in Germany will be out of pocket. Well, that doesn't seem like a very fair situation. So it's not neither open, there's not proper scrutiny, and they're picking up the bills. I think those are the problems as I see it. I don't see a fundamental problem with the concept. Just how it's implemented in Germany seems flawed. Stop there. I'm sure people got comments.
Thanks. Did you?
Yeah, if it's okay, Keith, I'm happy to go first. And
Yes,
start
please.
the-
Thank you, Georgia.
No problem. So you're right. I think people will probably try and exploit that kind of area. I would also say that, you know, there are use cases, people are using it, and it is sort of becoming popular. Big brands are also choosing to buy into it. One of the things that our research paper kind of looked at was opportunities of these blockchain domain names. Why are people choosing to use them? One of the things that people are choosing to do are using it to kind of do transactions between cryptocurrency back and forth. So of course that can be used for, you know, malicious purposes, but it can also really encourage good fundraising. So Ukraine, for example, during the war, you know, they put on their Twitter their cryptocurrency address, and they said, you know, please can you, they fundraised using cryptocurrency with different cryptocurrency addresses. If they had a blockchain domain name, Ukraine.crypto, for example, which is actually taken, then they could fundraise for over 275 different cryptocurrency coins in one easy address, and also circumvent any of the fundraising issues that you might have with international kind of fundraising. So there's different kind of use cases. Another one would be someone I spoke to, not saying I agree with it necessarily, but someone I spoke to believed that it was the next generation of digital identities. So you could have your cryptocurrency wallet, you could have a content-based blockchain page, your kind of web page, like a LinkedIn bio, that was just who you were. So in the paper that we've kind of written up, we actually do cite the first Web3 identity. His blockchain domain name is his identity. So I totally agree. I do think that it could be used for malicious purposes, particularly, right now the content isn't so great. It doesn't work so well. But in the future, that's looking to advance, and as that advances, I'm sure we'll see some malicious actors try and make use of IPFS, which they don't need a blockchain domain name to use, but it just might make things easier. I hope that answers your question.
Thank you very much, Georgia. And this is Keith. I see Thomas had his hand up. Thomas, go ahead. Over to you.
Thanks very much. And Chris, thanks so much for your remarks. Now, I did confirm that as a matter of last resort, it is possible under German law and in other jurisdictions to approach a recursive DNS resolver operator. Let me try to illustrate why I think that this is still worrisome. You mentioned that in the UK, the costs are getting picked up for installing a block. That is not the same in the jurisdiction that I'm in Germany. The opposite is the case. In Germany, the system is such that if you get a notification, and if you let's say it's what I called an egoistic motivation, i.e. rights holder, not malicious code or otherwise, no technical abuse that you're getting notified about. But if it's a, you get a notification from a rights holder, then you have a difficult time confirming that an infringement is in place or not. Then if you don't react instantly according to these latest decisions, you would be liable as a wrongdoer and be subject to the risk of having to pay damages to the rights holder. So that's a new dimension. But also, even if it were just the liability as an interferer, this Störerhaftung, if you don't act immediately, then the next thing that will happen is that you might get a cease and desist letter. And under German law, you have to pay the cost for the attorney that sends the cease and desist letter if the cease and desist letter is justified. The next step would be an escalation to court. Now, we have, I think in Germany, like 20,000 recursive DNS resolvers. So let's just assume for a second that company networks and other operators all get notifications by email from rights holders that they should make sure that certain domain names shall not be resolved anymore. Now, what is your hunch? Do you think that these recipients of those notifications will do a proper test of whether there's an infringement in place, or whether this is just an attempt to get a block installed for unlawful reasons, or without a legal position being in place? I think that the vast majority of the recipients will just install the block because they think it's not worthwhile fighting against it, or running the risk of getting a cease and desist letter that they might need to pay for. So I think that this scenario imposes a risk on freedom and diversity of speech, because a lot of operators will take the easy way out and say, okay, this content is not worthwhile defending. And don't get me wrong, I'm not in favor of defending those who are infringing upon third parties' rights, but what's next? There is a risk of, these court decisions being precedent for others to follow and send a lot of notifications about content that they want to be taken down. I mean, it's not getting taken down by the DNS resolver operator, but they want it to be inaccessible via as many routes as possible. So that's one thing. The other thing is that let's assume for a second we get proper court decisions. That everything is tested and there's actually an infringement in place. Unlike an access provider that has a user base that they know, so they have subscribers in Germany and they don't permit their user base, which is in Germany, not to access certain materials. The independent DNS resolver operator does not know where their users are. So it may well be that someone from outside Germany uses the system and their DNS query is routed to infrastructure based in Germany, or someone who's doing a DNS lookup out of Germany gets their DNS query routed through a recursive resolver that is in one of the neighboring countries or even further apart, or a company network is set up so that DNS queries are processed outside Germany. Now, German courts can only require operators to stop resolving in Germany, but this is practically impossible. So that means that a court decision in one jurisdiction, in order to be efficient, sufficiently efficient according to the court's views, which I don't necessarily agree with, need to make sure that there's a global block. And that might be, copyright infringements today. It may be certain limitations of speech tomorrow. And you do know that in Germany, we have quite strict laws when it comes to certain types of speech, which are protected in other jurisdictions. Let's assume that these operators serving customers at the global level would be required to implement all those blocks at the global level. So that might impair your rights in your jurisdiction tomorrow. And therefore, I think we need to be very cautious. And I think that that it should be sufficient for justified blocking requests to be limited to infrastructure operated in the affected jurisdiction, but not for the blocks to be installed so that they have global effect. Thanks very much, Keith.
Yeah, thank you very much, Thomas. Really detailed answer, and happy to carry on this conversation. We have 15 minutes left, and I did want to come back to the question that I posed a little bit earlier that was sort of teed up by Mark, and that's the sharing of information, right? And I think just to recap, as operators and entities engaged in this ecosystem, I think there are benefits to information sharing, whether it's patterns, trends, prevention or identification of things like domain hopping, registrar hopping of, the miscreants and malicious actors, basically, moving in very rapid fashion from one operator to the next, and doing so in some very creative ways. I think there's tremendous opportunity for improved information sharing and collaboration. But I think there's still a lot of work to be done. As Mark said, we're a long way from where we want to be, in terms of identifying, what's the data that would be helpful? What type of a collaboration mechanism could we establish? Is it something in the nature of a clearinghouse? Because there are so many operators out there, the need to be able to communicate and share data I think is one key open question in terms of the industry. I use that term loosely, our industry being able to self-govern and to demonstrate our ability to work together to improve and to mitigate DNS abuse in our roles, responsibilities, and capabilities. To be able to demonstrate to regulators and lawmakers that that we're keeping our shop clean to the extent possible. I know that's a big ask, but I'm curious if anybody has thoughts about about this in terms of sort of tactical engagement and things that we might be able to reasonably do in the near term, while aiming for something more significant or substantial in the long term. So I'll stop there. Happy to take any hands, input, thoughts. Just checking the chat here and the participants list. Helena, is that your hand I saw go up? Yes, thank you so much. Go right ahead.
Thanks, Keith. And yeah, I mean, I appreciate, like a very straightforward and very complicated question for the discussion. I think, yeah, for sure, as you identified, we need to start thinking about this, yeah, more tactically. We also definitely need to take into consideration that the difference between different operators around the table, and not everybody has, let's say, the usefulness in the same data, or even capabilities of sharing data, depending on, of course, the local limitations, and data protection is just one of them, but there might be others. But I'm sure there are some commonalities that we could identify jointly as what type of data could be useful and that can be shared more easily. And that we can only do to have with having as many operators as possible around the table, so that we get the different perspectives from different from different stakeholders, specifically technical community actors, and take it from there. So I think just starting this conversation is already, I think, a big step forward, and happy to continue that in a different capacity if we're not going to find answers in the next 10 minutes.
Yeah, thank you very much, Paulina. So I see a hand up from Andrew. Thomas, if you don't mind, I'll turn to Andrew first, since he has not yet spoken. So Andrew, thank you for joining.
To be fair, I have spoken, but I'll speak again. I just sort of reflecting on what you just said, Keith, and also sort of on what you said earlier, where you said about the importance of informed regulation and policy making. I think the tech community as a whole could reasonably be accused of repeatedly saying what doesn't work or what the problems are with regulation, but dare I say it is not so good at actually proposing solutions, proposing alternatives, proposing things that would work. And maybe what would be far better would be to say, you're proposing to do X, that won't work because here's a better way of achieving what you're trying to achieve. Because that I think is what's really missing and has been missing for a long time. I think embrace the sort of regulatory community and policymakers and so on, but actually giving solutions rather than problems. Because otherwise, I think, as is being seen increasingly, from what I can see, that sort of regulators and legislators have lost patience with the community. They certainly don't buy the idea that the internet's global, so therefore somehow can't be regulated, which I think even now some of the big internet companies still say to me that that's how it should work. I think that's just not a credible position. So I think inaction will lead to more, dare I say, bad, uninformed regulations and policies. So I think now the tech community needs to step up, engage and provide solutions rather than barriers and problems.
Yeah, thank you very much, Andrew. I completely agree, and I can speak to the experience in the ICANN community for GTLD policy development is we know that there's been significant frustration among governments, certain governments, and certainly the European Commission, about the length of time that it takes to conclude the policy work. And I think those of us who are active in the ICANN community on a regular basis recognize that we, as a multi-stakeholder community, need to do a better job of scoping and chartering the work of our policy development activities in a way that is narrowly focused, targeted. The term that people have used are sort of bite-sized chunks, some manageable amounts of work that can be concluded in a reasonable bit of time. We have recent experiences of the opposite, including some of the work around the EPDP phase 1, which was the policy development work that needed to take place in reaction to GDPR. And there's probably a series of others. But looking ahead, I think particularly on this topic of DNS abuse, while the GTLD contracted parties have taken the first step in taking on the new voluntary commitments that I mentioned earlier, to meaningfully act on well-evidenced and actionable reports of abuse. It's a pretty significant step, but it's not everything, and it's just the first step. There's more policy work that needs to be done, and we are very, very focused on the need to identify key topics for policy development and to make sure that that work is scoped and chartered in a way that can deliver in a timely manner. So I completely agree with your comment. I just described, sort of the little snapshot into the ICANN GTLD space, but I think your point is a much bigger and broader and valid one across the, up and down the stack and across our ecosystem. So thank you very much for that. So Thomas, to you, and then I see Peter has his hand up. So Thomas.
Yeah, thanks very much. Just a quick response to Andrew's point that we should come up with suggestions rather than moaning. And Keith thankfully mentioned the Top DNS initiative, and there are a couple of other initiatives, as you know, that are working on fighting DNS abuse. So I would put a link into the chat in the next couple of moments. But I think that, in addition to the contract changes that at ICANN that Keith spoke about, which I think going to corner the bad actors quite a bit, because it's typically the good actors that we talk to and that we see at events such as this that don't need any education. But it's the bad actors that we need to focus on. And also, I think, what we are looking at are ways to facilitate the exchange of information between the various actors. First thing that we need to do in order to achieve that is stop talking about DNS abuse, because if you talk to a hosting company, they don't even know what it means, because that's a term that they don't use. They talk about phishing, farming, and the like. So we have come up with a detailed spreadsheet detailing abuse scenarios and who should take action on what. So you find that on ECO's website. And also what we're currently trying to set up and spec out is a trusted space of collaboration where, we can try to work together more closely so that action can be taken before abuse notifications hit the abuse desk of the various players. To illustrate this in 15 seconds, let's say there's one person that you trust. That person has worked on a phishing campaign. That person found out that there are 38 domain names involved, over 5 registrars and 15 hosting companies. If you trust that person, you get that information after they've confirmed the phishing campaign. You can then take down the domain name immediately and thereby reduce the uptime of that given domain name. Because let's face it, today if a registrar is in the wholesale business, they send a notification to the reseller. That reseller might have a reseller itself. Before everyone is given like 48 hours to respond, it's far too late to take good action. So we need to speed up and be more efficient in the exchange of data. Thanks so much, Keith.
Yeah, thank you very much, Thomas. I completely agree. And you mentioned sort of the trust in notifying, the trust in notices. I think that's a whole separate but very important conversation, is the role of trusted flaggers or trusted notifiers in our ecosystem. And particularly if we're relying on these actors to provide notice that would be essentially asking or requiring action outside of sort of court order due process, and what are the implications there across up and down the stack and across the ecosystem, including the impacts on the end users. Thanks for that, Thomas. Peter, over to you, and we have about 4 minutes left in the session.
Yeah, thank you. I promise I'll not eat all of this. I would like to agree with Andrew to the extent that the technical community, of course, has a certain responsibility in contributing to the problem solution. But I think, first of all, I think the technical community has done a lot in that direction. I think we've also improved our communications quite a lot. But then there is the basic question of in whose ballpark, or in whose field is the problem right now. Like, technical community can help solve technical problems, and to some extent non-technical problems, for as long as we have the technical measures or means for that. Now, an example that Thomas gave, that we hear in different flavors, that the cross-border enforcement is difficult. That is nothing that the technical community can really solve. When we hear that, oh, MLATs are so complicated, therefore you need to do something, I think that is something that we should be really, really careful about accepting as a problem on our side. That is something that, of course, politicians need to solve, governments need to solve or help solving. We can do our part, but we can't accept all of the problems that arise from cross-border issues. And like Thomas said, if somebody just doesn't accept an order or something, that should not be a good justification to move it closer to the core. And that is something that I would like to emphasize here. Content control at the infrastructure core will not work by design, because the farther we go down the core, the farther away we are from the content, and the lesser the granularity is. It will, of course, always by design lead to overblocking or similar problems that then again are on the societal side. So we need to be aware of that, and we need to improve, maybe even further, the communications that policymakers understand that there are certain limitations doing things at the infrastructure level. Thank you so much.
Thank you very much, Peter. Very well said. Completely agree. And again, gets back to sort of the theme of the roles, responsibilities, and capabilities of each actor in terms of being able to mitigate online harms, DNS abuse, DNS security threats, whatever terminology one would like to use. It's just critically important that we can ensure regulators, lawmakers, policymakers understand the distinction, and that we can really drive the action, the mitigation action, to the most appropriate actor, and particularly in, ideally taking action as close to the source of the harm as possible. So I think that's very well said. So we are at the bottom of the hour, so I think we are essentially at the point we need to wrap up. I see Carolina from the DNS Research Federation has her hand up. Carolina,
yeah, Keith, I just wanted to come in with a quick point, just to let everyone know this session was organized by the Dynamic Coalition on DNS Issues, and we're hoping to continue this conversation in the global IGF. This session was titled Mind the Governance Gap, and we submitted a proposal to discuss how to close that governance gap. So I do invite everyone in the room to keep an eye for that session and to join us in continuing developing this conversation and thinking of multi-stakeholder solutions together. So just a quick mention to our forthcoming activities in the global IGF.
Thank you very much, Carolina. That's perfect ending, perfect sort of wrap up. And yeah, the Dynamic Coalition on DNS issues, we hope to be and expect to be the vehicle for us and those of us engaged in this community to continue these conversations under the IGF umbrella. And so, Carolina, thank you so much for you and your team at the DNS Research Federation for helping to coordinate both the Dynamic Coalition work as well as this session today. So thank you all. Thanks to the panelists. Thanks to the participants. It was wonderful to see everybody remotely. And I hope those of you in Tampere are having a wonderful visit. So with that, we'll wrap up the call. Thank you.
Thank you.
Thanks very much.